Hello, everybody. Thank you for joining us. Thank you, British Chambers of Commerce, for giving us this opportunity to share today our knowledge and our experience with you regarding real estate business, support measures, and our practical advice for the real estate. Today, I am Vytautas Šilinskas, and I will present measures in general what are available for the business. Meanwhile, my colleague Simas Paukštys will present probably the most interesting topic of today, which is real estate subsidies and rent subsidies. So we are both senior associates at law firm TGS Baltic, which you probably know and is one of the leading law firms in Lithuania. We are planning to spend with you about an hour today, half an hour for Simas and half an hour for me. Maybe we'll stay a little bit more for answering your questions. So if we have time and you have any questions, we will be available to answer them. So do not hesitate to provide your questions in the chat box. We'll go through them and answer if possible even today after this webinar. So without further ado, let's probably start with Simas knowledge sharing.
Thank you, Vytautas. Good morning to everyone who's listening to us. Let me just put on my slides. I hope you're seeing them well. And let me start without any further intro with key messages after 2 months of quarantine, as well as a short description of rent subsidy and then foreign initiatives, what we have seen, how the country, how the states are coping with this situation at the moment. So what are the key messages that we learned, we've seen after 2 months of quarantine regarding real estate? Well, first of all, there were some changes to legal environment regarding office leases. The government imposed no restrictions on administrative premises, allowing business centers and other buildings used for offices to continue to be open and operational. So on that side, there were no major changes to environment. However, in other areas, especially in food, sports and health, and entertainment areas, those were affected by the quarantine regime that was imposed, that was set up from 16th of March by the government order. And really our key takeaway from this is that there is a very rigid discussion whether these quarantine measures really affected ability to use the premises as they are directed more to the restrictions to carry out activities rather than just to prohibited use of premises. And these discussions will lead to some sort of difficulties in negotiating discounts, as well as even in some cases maybe to possible disputes. And there are arguments on both sides. However, we believe that economic logic should prevail, meaning that although the government order is set up and worded in a way that it is directed at the business activity. However, if no contracts, especially lease contracts, are concluded just to have them concluded, they are concluded and then signed and then carried out for the profit of both parties. And so if there's no ability to use the premises for economic activities, and then the tenant is not receiving any income out of it, we believe that there's a strong argument there that maybe the premises are not fit for use for that matter. Of course, this is very subject to very specific lease agreements that we looked, and what kind of provisions, what kind of inter-party regulations are set up there. But then again, from our experience, very few lease contracts address the current situation in a way that would clarify this, let's say, gray zone area, whether the state actions or the effects of the pandemic itself causing the economic downturn, as well as inability to fully use leased premises, whether these factors should be considered as a risk of a tenant or of a landlord. And, in majority of cases, we're talking about leases, as the contracts do not clearly address these sort of situations, we can only rely on a very basic set of rules established in the civil code regarding hardship. On certain occasions, tenant is and will be in the future able to request changes in the lease contract due to hardship, which is a legal concept that allows one party to request change in a contract to certain provisions of it, if due to circumstances that could not have been foreseen or controlled by the party, and risk of those circumstances is not taken by the party, makes it substantially harder to the party to carry out the contractual obligations. However, just only as a side note, this legal tool is not to, how to say, it is set up to retain the balance, not to relieve one party of its obligations, but to step a balance. That is also quite difficult. Moreover, when we are talking about lease contracts and the government order did not very clearly stated that use of premises is prohibited, application of this legal tools are also, well, is quite narrow and maybe only applicable if either the tenant's business is severely affected by the quarantine, the tenant faces substantial financial problems, or the entire lease market will go down, substantially dragging down the average rental prices. Both of these factors mainly are flashbacks to the previous financial crisis, where these sort of rules were applied. So these are the main key takeaways regarding leases at the moment. There are a lot of tenants are facing at least some degree of difficulties, and there are a lot of negotiations going on. And we'll see how they will turn out. And when we're talking about the future, well, a lot actually rests on the duration and severity of this situation, because we should not forget that we are currently only at the, let's say, first stage of this pandemic, and it is highly likely that it will reoccur. And if objective reasons like the quarantine regime, or as I mentioned, second wave of virus or additional actions of the government, as well as subjective reasons, let's not forget about them, like people's fear to use more public spaces, social distancing, fear of economic crisis lingers on. If this situation lingers on, and the entire market will, at least to some degree, turn south, and there will be a lot of a lack of cash on both sides, rising the tensions we will see a huge increase in number of litigations, especially hardship litigations. It is worth noting that this hardship do not directly revolve around the quarantine regime. It is, can also be used afterwards if the financial standing of either party does not improve, and it is substantially harder for one of them to carry on. As well as we already have a number of cases where the litigations will start in the upcoming months. So it is very clear that we will see a new wave of litigations, and possibly even new rules tailored for this situation set up in the case law. But notwithstanding this severity or duration of the pandemic, and whether or not it will have a huge or minimal economic impact, lease contracts will definitely be more tailored to address these kind of situations, especially on questions of risks and cost allocation. For example, who should bear increase of costs to maintain any new health and safety standards imposed by the government, or just as optional requirements. To what extent landlords should take on the risk of possibility to use the premises, as well as we'll see more tailored provisions regarding purpose of use and inability to use leased premises. What we are seeing now in most of the lease contracts is that these sorts of very basic provisions are very bland and do not specify what sort of activities to what extent should be and can be carried out in the premises, and these provisions are not linked, not entirely linked with other provisions of the contract that again specify the manner of payments and the right to terminate the contracts. But again, as I mentioned, one of the, well, it's not probably even a prediction, it's more of a forecast that the case law that we will see in the upcoming period of 1 to 3 years time, especially if we're talking about the case law of Supreme Court of Lithuania, will mold future changes to the contracts and to the situation itself, how it should be treated. And we can only hope that courts will take on a similar approach as they had during the 2008-2009 financial crisis, but there may be some other questions raised by the courts, as well as more tailored case law regarding those questions on ability or inability to use the premises. So these are the future, let's say, prediction forecasts for us, and these are the main key takeaways from these 2 months' time. So without wasting any more time, let's move on the next topic I wish to present. Is, of course, the rent subsidy. As Vytautas mentioned, other state aid measures will be covered by him, and I will talk solely about this subsidy for rent. But first, let's take on a short look at foreign initiatives. What sort of measures, what sort of road other countries decided to take on. And from what we know, not all countries decided, only a few countries decided to give out subsidies. A lot of countries decided to rather go with more regulations on contractual matters of the situation. And for example, countries like Germany, United Kingdom, Poland, Czech Republic decided to limit right to terminate contracts to safeguard the tenants if causes to terminate the contract arise from this COVID-19 effects. And some of them, in addition, like Germany, due date of payments is also prolonged. Of course, the outstanding sums don't go anywhere, but government is giving, Germany is giving them some, let's say, breathing space to settle with the landlords or any debts within 2 years' time. Similar to Germany, Czech Republic decided to go that path also, but only limited this period to fully settle with the landlords by the end of this year. In Poland, in addition to restricted right to terminate the contract, the tenant is also allowed to demand a prolongation of lease term. And what is interesting is that, well, basically, if the tenant requests to prolong the lease term, the landlord is ineligible to refuse. Taking a look at other examples, well, Italy and France decided not to allow to demand payment of interest or other penalties that arise from inability to make payments to the landlord for COVID-19 effects. And in addition, Italy decided to give tax reliefs to certain types of tenants. Finally, as you may also know, our subsidy model was taken basically from Sweden. Sweden has adopted a very similar set of measures, meaning that Sweden is giving out a subsidy to the tenants. However, Sweden decided not to limit the scope of applicants, but rather to limit the scope of subsidy to a greater extent than Lithuania did, and they limited their subsidy to basically 25% of initial lease fee. So as you may see, there are a lot of different approaches to the situation, and who will benefit the most, we might as well never know, as the devil is always in the details. And what are the minor aspects of these sort of provisions, of these sort of measures that were implemented, and from our practice, from our experience, sometimes these minor aspects sometimes are the most important, become the most important questions. Anyway, without any set of measure has its own advantages and disadvantages, as well as means to exploit any set of rules or just to get tangled up in them. So let's not linger on that and just move back to Lithuania and see what we have right here at hand. So talking about rent subsidy in Lithuania, very specifically, it is governed by the order of Ministry of Economics and Innovation. Its administration is given to state enterprise in Vega. Rent subsidy can be received by both legal and natural entities that carry out business activities. And however, there are some limitations to the scope of possible applicants for the subsidy, and Lithuania decided not to give out subsidy to large companies, limiting that entities whose annual income in 2019 was bigger than 50 million euros or annual balance sheet on the end of December of 2018 does not exceeds 43 million euros are ineligible to apply for the subsidy. The subsidy is going to be provided for the period starting from March 16, as it is, as I mentioned, tied to order of government that sets out the quarantine regime, and the subsidy will end 60 days after the end of quarantine or on 31st of December 2020, whichever comes first. But entities are eligible to apply to Invega to receive a subsidy even for the previous months until the 1st of December this year. Of course, we know perfectly well that the size of the subsidy equals to 50% of rent price plus additional services that are included in this subsidy size is fixed and then set based on the invoice that was issued by the landlord on February 2020. Of course, everything is VAT excluded unless the tenant is not a VAT payer, and of course, finally, the size of the 50% is the maximum size, but amount of subsidy cannot exceed factual amount of rent, meaning that if the discount is 60%, the subsidy is 40. If discount 70, then subsidy is 30, and so on. And what are the key conditions of the subsidies? Well, just note for the very beginning that there are some additional limitations and conditions that are not listed here above. However, I have not included them as they are either very self-explanatory or applicable to only a very narrow circle. So, of course, the main condition is that main operations of the tenant are prohibited under this government order that imposed quarantine measures. Basic rule of thumb herein is that subsidy is guaranteed under two conditions. That one, the economic activity was prohibited by the government order, and two, that the tenant did not carried out these activities, meaning that loosened restrictions are not as important. However, it is not entirely clear to what degree and to what extent these loosened restrictions came into play, given that for specific types of tenants, this prohibition, let's say prohibition period, ended with 2 or 4 weeks after the quarantine was implemented. And it is unknown whether this would disqualify them only for receive a part of subsidy, or the subsidy size will be decreased. And furthermore, what is also worth mentioning is that only the main operations of an entity come in play and are important when considering whether or not the subsidy will be given out. So any additional supplementary activities of an entity, of a tenant, may be very well be carried out, and they do not make the tenant ineligible to apply for the subsidy. Next condition is, of course, that tenant has filed the financial statements of 2019. This is a precaution, of course, to verify, to check whether other conditions are met. Very important condition is that the tenant at the end of last year, on the 31st of December, was not in difficulty or faced difficulties at the time of application, and is not in bankruptcy, is not being restructured or liquidated. The difficulty, whether the company is in difficulty or not, is decided under European Commission regulations. And the meaning that the entity is not facing the it's not facing the difficulty that more than half of its subscribed share capital has not disappeared as a result of accumulated losses. It's not subject to collective insolvency procedures. It's not received a rescue aid and other conditions. Next one is that, of course, lease contract signed before 15th of March is valid at the moment of application to Invega and duly registered with real estate. Key note here is that, of course, all later supplements and amendments to the lease contract should also be registered with the real estate register, but from our unofficial talks with Invega, there's a note that they do not consider as a major issue that some of the amendments are not registered, and this would not automatically disqualify a tenant from the application. However, it is, of course, better to have them duly registered in the full scope. Other important condition is that tenant and landlord are not related, meaning that the tenant and the landlord cannot be in the same company group, as well as if the landlord is a natural person, he or she cannot have majority voting shares in the tenant. Now, are these requirements and conditions too much? Well, it's really hard to tell, and it really rests on your viewpoint, on your outlook. It is clear that the government went to craft these requirements to minimize the possibility to cheat and to maybe apply for something that you shouldn't have, and not for scope and intensity of the aid. And it is quite sad as not all suggestions that were voiced by the associations, by the businesses were heard, and the government really took on this road just to maximize the security and not the intensity of the aid. And what is more, it's sad that it's not very likely that any major changes to this framework will be introduced, at least in the near future. But nonetheless, it is important to understand these issues and limitations, to better understand underlying obstacles that can be important in negotiating, let's say, contract amendments or negotiating a discount. So first group of these issues that we see is an exclusion of directly affected tenants, group entities, and those that undergo restructuring. As it is very clear that state aid is given only to those entities whose activities are listed in the initial government order, and do not include entities, tenants that are severely affected by the quarantine, its measures, but are carrying out those supplementary activities, let's say business-to-business operations, giving services to other businesses, and they have suffered a substantial drop in income because of lack of orders, but still not qualify for the subsidy. Also, we cannot find substantial arguments why subsidy should not be given to entities that undergo restructuring, as it does not mean insolvency. It does not mean that that the entity, the tenant, has financial problems. Besides, there are other criteria set up to ensure that company is not going under, and subsidy will not just be to cover other financial obligations of the entity, as well as we find lack of arguments why group entities are also excluded, as they are very common business practice and not something that is prohibited by other legal regulations. All taxes are usually paid up for that, and it's just odd from our perspective. Other group of issues is that no legal mechanism is set up to ensure that, well, subsidy will reach the landlord. The framework requires to pay the subsidy to the landlord within 5 days after it is received from Invega, but there are no enforcement measures in place, as the subsidy is paid out to the tenant and not the landlord directly. Although this was a suggestion, the landlord may not be even aware that the subsidy is received, and in such cases, there is no clear procedure what to do from the landlord side. Should he go to Invega? Should he go directly to court, or take on any other additional actions? And we don't know whether this risk, this issue will materialize in a greater scale, but it is something that should be also considered and clearly described and specified in any amendment to the lease contract, that on the rent discount that the parties are agreeing on and signing on. Also, subrent is not regulated and described in the framework. Our belief is that this may not be an issue, and Invega may possibly take on a view that it is all the rules that apply to the rent apply at the same extent and conditions also to the subrent, but it's just something worth noting, especially if the parties, tenant and subtenant, are discussing and negotiating on the discount. And finally, there are other administrative obstacles that may be worth considering, like registering, filing, or that may not actually be very relevant or necessary, but there are in place, like registering all the lease agreements and then amendments, filing all the financial statements to the real estate, to the register of legal entities. And we believe that some of these conditions, some of these limitations may be a little bit redundant and not entirely necessary, but it is what it is. So just to summarize, I'm really at the end of my presentation. Sure, there are issues with the framework, and we really can't say and don't know at the moment how many tenants will be able to use the subsidy, and how much of that allocated 100 million euros will be used by the end of the this subsidy period. But if nothing else, at least these measures brought to the table landlords and the tenants to negotiate and talk. And we believe that is not it's not a bad result, at least to have that, because the compromise and talking of the parties, to our view, is it's the most important aspect to resolve any harder situations, and the only reasonable way to solve the problems. So thank you very much for your time. I will transfer word now to my colleague Vytautas. And should you have any questions, please write them down, and then we will try to answer them by the end.
Thank you, Simas. I totally agree with Simas that requirements are too strict. We have provided our suggestions to the draft of this document to loosen up them, but probably due to lack of time, most of them were ignored. And at this moment, €0 have been paid through this measure. Okay, it started not that long ago, but nobody has received a single euro. There are more than 2,000 applications provided for total amount of nearly 1 million euros. But that's like 1% of what was promised to pay. If the government was planning to pay 100 million euros, and now only applications are provided for less than 1 million during this period. So this probably clearly shows that the restrictions are too tight and they should be loosened up. We'll see, and we hope that this will happen in future. Now I will show you and go through probably as fast as possible what are other measures there are that are currently working or should start working soon. So not only for the real estate companies, but for the business, other businesses as well, because if you are a landlord, probably you might be interested if your tenant can get any money from the government, so he could pay you rent. So, okay, I hope you see the presentation. So the measures, what are the first is tax relief for measures, tax relief measures for business. That's this one is working. I'll check chat. Okay, yeah, we'll see everything. Good. So wage subsidies, you probably heard of this. Free money to micro undertakings. This is new, started only a couple of days ago. Financial assistance for businesses and other measures. So start with the first, which is started really fast and is working. The government has changed the laws and said that we'll demand no default interest for overdue debt, tax debts. So, and as well, they will not enforce tax recovery during the quarantine period and 2 months after. So essentially, this means if the company is indicated in the list, which was provided by the state tax inspectorate, this company can stop paying taxes without any consequences, but for the limited period of time. And it's not like you will not have to pay them. You will, but only after some time. It's like a loan from the government. So everybody is concerned what happens after the quarantine and 2 months passes, whether we have to pay immediately. So the government proposes other measure that you can apply and agree on interest-free tax loans with the government up to 4 years regarding the taxes that are paid to state tax inspectorate and up to 1 year for social security payments. As well, there are no interest on old you can apply and ask that there would be no interest for old tax loans, and ask changing their conditions. If you have agreements regarding tax loans, you can apply due to COVID hardship and ask change them. These measures are working pretty well. 50,000 companies were included in the initial list of tax inspectorate, which they have made automatically based on the information that company has provided, which is to statistics department, on the information to the statistics department on its main business. And then 5,000 additional companies were included in the list, which had and which applied to this to be included. And I have I'd say, near 100 real estate companies went through, checked whether they are included in the list or not. And less than 10 companies were included, nearly 10 companies. So most real companies are not in this list. However, some known names were automatically included. For example, Acropolis, Prosperitas Baltica, which manages CUP shopping mall, EK, Vilmesta, and other. These were done not by the request of these companies, but due to the fact that they have reported some business activities that state tax inspectorate considered as forbidden or affected. For example, Acropolis was listed because it's one of its activities is sports and entertainment. Prosperitas Baltica because it was listed as retail shop, so and so on. Our tax law team advises when you go to ask for this tax loan to be realistic. Do not expect to get full term or for 1 year. And be ready to present your calculations why this or that period is needed. They as well recommend to avoid expenses that are unrelated to the business, do not distribute and pay dividends, and do not repay any loans earlier, because, well, the state would not be happy if they grant you loans and then you pay dividends to yourself. The next measure is employee subsidies. You can get a wage subsidy during downtime, 90% or 70%. For the people who are not working, you send them on downtime, you pay minimum wage or higher and apply for the subsidy. There are subsidies for self-employed, and there are measures announced and recently approved, which will be applied after the quarantine. So wage subsidy, this one is working. People are receiving, well, companies are receiving money, and basically the main takeaway is probably which amount should be paid if your employee applies to both, let's say wage subsidy and he is on sick leave, which was also, well, requirements will loosen up and a lot of people went on sick leave. So our recommendation is here that you indicate that if the person is on sick leave, then you do not put him on downtime. Although the law doesn't clearly allow this, but our institutions allows this practice, and they promise to pay the sick leave to such people. So you should not put your people who do not have work on downtime if they are on sick leave. Also be aware that if you use this measure, you'll have to keep at least 50% of your employees for 3 months afterwards. Additional employment subsidies were approved of amount near 1 billion euros. So the government decided to extend payment of wage subsidies for up to 6 months, as you see here the numbers. But you either would be in the list of the state tax inspectorate, which were affected by COVID-19, of companies that were affected. You should hire an employed or have applied for the subsidy prior to the end of quarantine. There will be better conditions which are approved, but only for the special list of companies. So keep an eye on that, and maybe real estate companies would be able to apply for this. Currently, the list says that it should include green companies and innovative companies. I'm not sure how they will define that. There are subsidies for new workplaces, apprenticeship support, as well. The additional payouts will be handed out for the unemployed person and senior citizens, which you probably heard of, and which is really discussed as a measure to buy votes in upcoming elections in this autumn. And more spending will be made through welfare programs. Free money to micro undertakings, which is really interesting and working. The company has to have less than 10 employees, 9 or less employees, and it has to be included in this STI list again. So if you are not included in the list, maybe you should consider doing this, because I've checked what companies applied there and who is included. I found really strange things there. For example, I found 9 law firms included there as well, but it's really rare, and it's hard to say how they got there. So back to the topic, STIs, how it works, this measure. STI sends invitation. Currently 22,000 invitations were sent. The company receives it through My STI webpage, and currently only 11,000 have applied. So you should check, maybe you have received this invitation and you just not noticed. Well, one of your group companies, let's say. Subsidy is up to 50% of personal income tax paid in 2019. Around 900 companies already received this amount, although it started only this week. So this is, and no obligations to repay these amounts or anything. It's just free money for the companies, and the requirements are really low, so you just have to get the invitation. The next measures, financial assistance for businesses. These were announced as a great support for the business, but these are actually various loans. And one measure is working, but it was not provided by the government, is payment moratorium, where banks agreed to postpone loans. Other measure provided by the government together with this is the compensation of interest. However, only 22% of the planned amount was paid through this measure. Loans for payable invoices, 10% paid out of the planned amount. Loans for business most affected by this virus, almost third of this amount has been paid to business. Loans from alternative financiers, 2.5%, well, almost nothing. Individual and portfolio guarantees as well, almost nothing. And aid for business fund, it's only coming soon. I'll go really fast, a bit more detail in these measures, but not too much. So payment moratorium, you probably heard of this. Up to 6 months, banks agreed to postpone payments of loans without changing any other contractual terms, meaning that they will not increase your interest. The loan has to be up to 5 million per group. It's not applicable to agreements without fixed repayment schedule, and clients must meet certain requirements, meaning there has been no significant delay in payments, no insolvency has been declared, and equity capital was positive. And as well, banks would not like you to pay dividends, granting other loans, and so on, if you get this support. Compensation of interest. The issue is this one applies to only small and medium businesses, but Invega compensates us up to 100% of interest, because banks, although they defer payments of the loan, they still want to get the interest. So this is why the business, together with that measure, has to apply for Invega as well. And one of the conditions to get the compensation is that the bank has to agree, similar to the rent, the parties have to agree for the postponement of payment to reach some kind of agreement. Applications are provided directly to INVEGA. Loans for payable invoices. This one, again, only for small and medium businesses, granted by INVEGA, based on the fact that you have invoices which were not paid because you provided the services or supplies to companies that were affected by COVID. And this is not subsidy again, this is loan, so it's kind of factoring. So factoring that you provide the invoices and you get certain amount as a loan for that, up to 500,000 euros. Loans for businesses most affected by COVID. Loans are granted from financial institutions that you see here, well, quite a lot of conditions there as well for apply, and that's why not that much, not amounts that are granted through this measure isn't that high as well, not that much as it was planned. But maximum loan amount is 1 million euros. And the benefit of it is, of course, low interest rates, and the loans provided without any security, which normally the bank would not agree. Loans from alternative financiers. This is another option to get loans for small and medium businesses. Well, these loans are as well provided from Novi Finance, New Capital, BNP Finance, Factories, not the biggest banks as you see here, or financial institutions in Lithuania. So you would have to apply to these for more information, or INVEGA. Individual and portfolio guarantees. This one is if you want to get additional loan from your current bank, from, well, biggest banks in Lithuania, and INVEGA promises to guarantee your loans. Individual guarantees to all enterprises, up to 80% of the loan, and up to 1.5 million euros, depending on the size of the company. Portfolio guarantees, these should be provided, but I'm not sure if anyone has got this already, because the requirements are quite strict, and this started not that long ago, and banks are still hesitant to provide the loans because, well, the government guarantees only, again, 80% of the amounts loaned. And this also means that the company has to pay additional to INVEGA for the guarantee. Aid for Business Fund. This is aimed to medium-sized and large companies, and the fund will purchase equities, purchase bonds, and grant loans. It should start soon, but it hasn't yet, and it will be an option if you cannot get financing through other means or measures. Main obstacles, as far as I see them, is that most of the measures require that you have to be a small or medium-sized company. So medium-sized company is the company that has less than 250 employees, turnover less than 50 million, and balance sheet less than 43 million. Another issue that Simas mentioned as well, and most of the support measures require that the company must not be an undertaking in difficulty. And there are three main obstacles for that. And because if you, let's say you have accumulated losses that are more than half of your subscribed share capital, you are undertaking in difficulty and you cannot apply for most of the measures. Even though you might be working profitably for, let's say, last 2 years. One of my clients has this situation. Other requirements include the debt to equity ratio and the EBITDA interest coverage ratio, as you see here. Other measures that are announced or planned, government allowed full use of climate change program, as well road maintenance and development program, as well promised to accelerate the multi-apartment building renovation program. So the government is trying to increase the spending. Again, they are trying to increase the spending through planned investment programs and procurements, including buying or building the real estate. As well, the government promised to subsidize or provide financing and liquidity measures to municipalities so that they could also end their investment programs. I'm not sure how this will work in practice, because I heard complaints from Vilnius municipality that at least, well, financing for one of their projects was reduced, but well, maybe that's just an exception. Then the last of these list is that the government is planning to reduce liquidity requirements for banks and hopefully to encourage them to increase the lending and stimulate the economy in this way. Utility providers are allowing to postpone payments, as well as municipalities. I haven't checked all of them, but for example, Vilnius municipality has declared that they will not collect real estate tax and rent for its property from the business whose activities were restricted. There are also sector-specific measures. Currently, this most supported sector is probably agriculture. Most measures planned for this, and no surprise. But as well, there are measures announced for food processing, culture, transport, and tourism. So, for my final thoughts. Expect the best, fast recovery of the economy, but prepare for the worst. Some economists, you probably know Mr. Doom and Nouriel Roubini, tells that there might be economic depression and a lot of insolvencies. But well, he's as a lawyer, probably he always sees the worst case scenario. Be active through your associations, because I have noticed that those who are working actively, who have strong associations, they get more support from the government. Their voice is better heard, and more measures are granted. Practices of authorities are often different from what the law says. For example, Simas mentioned that the law requires that rent agreements must be registered with the real property register. Nonetheless, in TGS says that maybe it won't be that a big issue if not, well, full contract was registered there. So, and there are a lot of, let's say, such practices that where institutions read the law in favorable way to the businesses, at least during these periods. And you might miss out a lot if you read the law only. Avoid but be prepared for legal disputes. Most people are going into negotiations now, but I see a huge problem, and a lot of cases are later lost, or people even go to the disputes if lawyers are not involved in the beginning. Because the start of the communication and how each parties approach each other with the arguments the most convincing in the legal case. Later, if you come to the lawyer later and he proposes some, wow, really good tactics of defense of your case, the court might be hesitant to believe that these thoughts were your initial thoughts if your earlier communication has showed, I don't know, that you were not cooperating with the other party, that you were not intending to continue the lease, or I don't know. It depends on the circumstances, but you get the point that it's like with the doctor. It is better to get earlier than later than appointment. And that's it for today. And I hope this was quite useful. You probably now have a knowledge of, I'd say, 90–95% of measures currently available in Lithuania. So please do not hesitate to provide any questions if you have. Yeah, I see there's a question from Per, that whether we'll send these presentations to the participants. I'll ask how to do this, but yes, of course, we have no issue with sharing these presentations and we'll do that. Okay, there's another question that I see. That there's a question saying that our presentation is somewhat sided towards tenants, and landlords are also businesses that have costs and bank loans to pay. The shareholder partners and owners of companies have taken out profits from their companies good times and are not required to put money back in their company during bad times, support their employees, pay bills. So yeah, I might agree with that, that the landlords are in difficult situation as well. And not to get used by the tenants, there are probably several advices. Simas, you might add if you have anything to add. First of all,
yes, we see that it's quite a provocative question, given the current situation. Of course, the situation is that the main focus at the moment is, yes, leaning more towards the tenants. But from what we see is that mutual agreement and mutual cooperation usually is the best way to deal with these sorts of situations. And because as I mentioned during my presentation, everyone comes into the agreement, comes into the contract to benefit from each other and to have this basically mutual benefit. If one party of the contract is struggling, at the end of the day, the other party will not receive its income, and its benefits will be also reduced. So our view is that more from the legal side, especially talking about office leases, there are no specific regulations and regulation implemented by the government, and everything will actually rest upon the goodwill and cooperation of the parties. So I wouldn't say that the landlords are being forgotten or their interests are forgotten. It's just the main focus now is, yes, it has shifted more toward tenants, but that in any way, in any case, does not mean that the interests of the landlords will be also forgotten. As I mentioned, this legal tools that we have currently at the moment required to find the balance, not and it should not let one party benefit from the other. So just to summarize my views on this question is, the parties should just sit out and talk. From our experience, those who stand together usually come out of top out of these situations. Maybe Vytautas, you have something to add.
Yeah, I agree with that. Well, my takeaway from this situation currently is that you always have to check whether you want further cooperation with the tenant or not, because some tenants are probably not worth saving. If you have to check what's the financial situation of the tenant, maybe if they are in a hard situation, then you have to check whether they might get any government support. That's why we were discussing this. If they will get government support and you believe that they will survive, it's worth saving, probably not looking for the new one. It's mutual benefit for the both. But if you see that the tenant is not going to survive and their shareholders are not willing to to support the business. They are not willing to provide personal guarantees. They are not providing additional capital to the company to pay the rent. Then it's probably not worth saving such tenant. It's not worth cooperation. And probably, well, that's my takeaway. Real estate business is just as any other business. It's just, it's not charity. I noticed that some tenants got upset because they were not provided with the discounts, but well, it's not mandated by the law. So that's my takeaway. There's always case-by-case scenario, and you see whether it's mutually beneficial for you to continue cooperation with this tenant or not. So I hope this answers our questions. And well, do not hesitate to contact us directly if you have any other questions, not only related to real estate, because we are a full service law firm and we advise on any questions. Thank you and goodbye then.